Hello, my name is Matt Johnson. I'm a partner at Devine Millimet. We are the legal counsel to the New Hampshire Association of REALTORS. On behalf of the risk management group, we would like to offer a few videos on certain risk management topics. This is a new delivery vehicle that does not take place of, but is a supplement to our normal risk management seminar each April, Realtors in the Crossfire. The next seminar will be in April 2013, so please mark your calendars. As an additional resource, please look on the NHAR.org website for the purple box in the bottom. That is the risk management box. If you click on that, it'll provide you access to the legal resource line, which provides you information on current risk management issues facing realtors, and you can also pose questions, which I'll do my best to try to answer for you. Here are the top 10 things not to do or say as a realtor. Number 1, do not list a property as having more bedrooms than the septic system rating for the property. This is a growing area of litigation in New Hampshire against realtors. Number 2, do not fill out the seller disclosure form for the seller. This is an important risk management tool and device for you to protect you, but you lose most of those protections if you fill out the disclosure form for the seller instead of the seller doing it themselves. Number 3, do not guarantee anything during the transaction. What you say may to you be innocuous, but if the transaction does not go the way one of the parties wishes it to go, those guaranteeing statements that you made during the middle of the transaction will come back to haunt you if there is a dispute or actual litigation. Number 4, do not provide information without proper attribution as to the source. For example, if you obtain tax record information or property information from the town, make sure that the party that is receiving it knows that you obtained this information from the town and you are not independently verifying its accuracy. Number 5, do not regularly delete your emails, text messages, and voicemails. This information can be critical to defending yourself if there's a claim later made. This type of information is what you will need to give to your attorney so you can reconstruct the chronology and properly defend yourself. Number 6, do not rely on verbal extensions of the purchase and sale agreement or any listing agreements. No matter how well you know the other realtor or how well the transaction is moving, if an extension is needed, the extension needs to be in writing and signed. That way there could be no disagreements or misunderstandings afterwards as to what happened with the contract. Number 7, do not research on your own the sex offender registry. This is not your role as a real estate agent, and by doing so, you could impart knowledge to yourself that would put you in a position of having to disclose that information to one or more parties in the transaction and possibly having to withdraw from the transaction to protect the best interests of the parties. Number 8, do not provide legal advice to your clients. It may be tempting in the middle of the transaction, and your clients will know you and ask you questions, but make sure you do not provide information that could be construed as providing legal advice. That is impermissible under the license law. You need to advise your clients that they need to consult their own attorney to obtain information about what their respective rights may be. Number 9, do not refuse to respond to an agent or a client no matter what the situation is. If you stop communicating with another agent or a client, that is going to be grounds to set up a dispute later on and perhaps an ethics complaint against you later on. Communication is the key to make sure a transaction moves smoothly. Number 10, do not list a property without proper authorization. If you do not have proper authorization from all parties that have an interest in the property on your listing agreement, you run the risk of having a licensing complaint brought against you before the Real Estate Commission. When in doubt, make sure you check the underlying documents to ensure that all the parties who have an interest in that property are aware of the circumstances and are signing the listing agreement. If people do not sign the listing agreement, you cannot go forward with the transaction.